Hi, welcome to another episode of the Lawyer Society Legal Podcast. This is part 2 to the previous episode, which was about the interpretation of several provisions concerning custody matters between a father and a mother of a child. In the previous episode, I had interpreted sections 6 clause A of the Hindu Minority and Guardianship Act of 1956 and several other provisions from the Guardians and Wards Act of 1890 as well as the Hindu Minority and Guardianship Act of 1956. In this episode, we'll be talking about a particular provision from the Hindu Marriage Act of 1955, which must also be kept in mind when you are preparing or when you are appearing for a case concerning custody matters between a father and a mother, that is a husband and a wife. Now, this particular provision was pointed out to me during a discussion by one of our colleagues, one of the members in our Lawyer Society WhatsApp groups. And after he pointed out the provision to me, I went about reading the same, and suddenly I came across one thought which was so amazing to me, because the provision can be used in so many other ways which may be missed if we give it a very literal plain meaning or a plain interpretation. In this episode, we'll be talking about what that particular interpretation is. The provision to be discussed in this episode is section 26 of the Hindu Marriage Act 1955. As per this provision, whenever there is any proceeding under the Hindu Marriage Act of 1955, the court may from time to time pass such interim orders and make such provisions in the decree as it may deem just and proper with respect to the custody, maintenance and education of minor children, consistently with their wishes wherever possible, and may, after the decree upon application by petition for the purpose, make from time to time all such orders and provisions with respect to the custody, maintenance and education of such children as might have been made by such decree or interim orders, in case the proceeding for obtaining such decree were still pending, and the court may also from time to time revoke, suspend or vary any such orders and provisions previously made, provided that the application with respect to the maintenance and education of the minor children pending the proceeding for obtaining such decree shall, as far as possible, be disposed of within 60 days from the date of service of notice on the respondent. So what we understand from a plain reading of this provision is that the court hearing any proceeding under this act, it's not just a divorce proceeding, it could be any proceeding under the Hindu Marriage Act of 1955. When such court is hearing such a proceeding, it can make interim orders and also include provisions in the final decree regarding the custody, maintenance and education of minor children. And subsequent to the decree, this is the most important part, and even subsequent to the decree itself, when one party to such a proceeding comes and makes an application before such a court can make new orders regarding the custody, maintenance and education of such children. So they can revoke, suspend or vary such orders at any given time, and the court will have jurisdiction with respect to such orders. Now let us look at one particular case which I came across from the Uttarakhand High Court. The case cause title is Neelam vs Ashok Kumar. The case number is AO number 114 of 2013, dated 18/3/2013. In this particular judgment, it was observed that a divorce suit is pending inter se between the parties. So, when the divorce suit is pending, an application filed by the husband or for that matter it could be the wife under the Guardians and Wards Act of 1890 seeking custody is not maintainable. This is because, as per the court's view, Section 26 gives the court the authority to direct custody of minor children to be given to either of the spouses. In such a circumstance, the application under a different law is not entertainable. It's not maintainable as per the Uttarakhand High Court. Now, whether it is not maintainable is a question we can answer by reading Section 14 of the Guardians and Wards Act of 1890. Section 14 of this Act provides for the solution when there are simultaneous proceedings in different courts. If you read section 14, it says, if proceedings for the appointment or declaration of a guardian of a minor are taken in more courts than one, Each of those courts shall, on being apprised of the proceedings in the other court or courts, stay the proceedings before itself. Subsection 2 of section 14 reads, if the courts are both or all subordinate to the same High Court, they shall report the case to the High Court, and the High Court shall determine in which of the courts the proceedings with respect to the appointment or declaration of a guardian of the minor shall be had. So if they come under the same High Court, then the High Court has the jurisdiction to decide which court can proceed with the matter, hearing the issue regarding custody of the child. Subsection 3 provides for the scenario where the two courts are not coming under the same High Courts. So in such a case, the respective state governments must be deciding. If you are going to consider section 14 in an isolated manner, that is separately, then we can say that the more prudent way for the Uttarakhand High Court in the Neelam case would have been to refer the matter to the High Court and let the High Court decide which court should be continuing with the issue of custody. But as per section 4 clause B of the Hindu Marriage Act, which says that save as otherwise expressly provided in this act, any other law in force immediately before the commencement of this act shall cease to have effect insofar as it is inconsistent with any of the provisions contained in this act. So if we are to consider section 26 as governing custodial matters when a proceeding under the Hindu Marriage Act is pending, then we must say that section 26 overrides any other provisions in any other law insofar as custodial matters are concerned when a proceeding is pending before a court of law under the Hindu Marriage Act of 1955. But although this has not been said by the Uttarakhand High Court in specific, we can arrive at a conclusive finding when we read these provisions together that such is the case, because section 4 clause B overrides all other provisions regarding custody, and section 26, because it says when a proceeding is pending, such a court will have jurisdiction. Then when a proceeding is pending, there is an overriding effect. But what if such a proceeding has ended and a decree has been drawn and provisions regarding custody, maintenance and education of the child has been mentioned in the decree itself? Can the parties approach any other court in the future under any other law, not giving regard to the proceeding which is already ended under the Hindu Marriage Act of 1955? Now, this is answered by a very important case from the Delhi High Court. The case cost title is Sangeeta Sarin versus Kamlendra Malaya. It is reported in AIR 2010 NOC 902 Delhi. Here, it was observed by the Delhi High Court that it will be seen from what is laid down in section 26 of the Hindu Marriage Act 1955 that it not only empowers the court to pass interim orders with regard to the custody, maintenance and education of minor children, but also gives the power to make such provisions in the final decree as well. It also lays down that even after the passing of the decree, the court may from time to time revoke, suspend or vary any order passed in relation to custody, maintenance and education of the minor children. So here finally it was concluded that when a decree has already been drawn under the Hindu Marriage Act in some proceeding, in any proceeding, then it will be improper for a party to such proceeding to approach any other court under any other act regards to custodial matters of the same child. So here it is said that the proper course for the respondent was to have moved the same court for any variation in the order, but he chose to initiate fresh proceedings with regard to the custody of the child, which issue stood settled in view of the order passed by the Matrimonial Court dated May 2nd of 2002. The Honorable Justice went on to say that I feel that the act of the respondent in filing the petition under the Guardians and Wards Act was not bona fide and was an attempt to reopen a settled issue. So what if we bring in the concept of res judicata here? Will res judicata apply in such matters? If we see it is the same issue, it is the custodial matters, it is with regard to custody, and if the parties are the same parties to the proceeding under the Hindu Marriage Act which is already ended, and the court dealing with such a proceeding made provisions regarding the custody of the child, then even in my opinion it is not proper for the parties to approach a different court under a different act to re-litigate the same issue, provided I think the principles of res judicata must be kept in mind and must also be considered when we deal with this particular issue. What if the parties are different? It might be the grandfather of the child against the mother of the child going for the custody of the child. So in such a scenario, there are different parties, but the issue will be the same. So in all such circumstances, I think the principles of res judicata as under the Civil Procedure Code must be kept in mind when dealing with the same issue of custody when it has already been decided by a court under the Hindu Marriage Act of 1955. Whether the parties have to go before the same court under section 26, make an application under section 26, that must be kept in mind by the parties. On the other hand, you can also bring in section 4 clause B of the Hindu Marriage Act, as per which section 26, when it clearly says that the same court will have jurisdiction even after the decree is passed, then one can say that section 26 prevails over the provisions contained in any other laws even after a decree has been passed. So section 26 is supposed to have exclusive jurisdiction over such custodial issues if there has been a litigation under the Hindu Marriage Act already. So that is also another interpretation that you can give when you read these provisions together. I hope you found this episode informative, and this is a big issue, and I have written about this in detail in the June 2024 edition of the Lawyers Society Digital Law Magazine. If in case you want to purchase the magazine and read it, you can check out the description box where I have left a link for the same. And do share your thoughts and comments regarding whether res judicata is applicable in such matters, whether you are prohibited from applying under different laws when you have already settled the issue under the Hindu Marriage Act as per section 26. Also, do share this video with your friends, with your seniors, with your juniors, and the law groups wherever you are a part of, so that we get better reach and we are able to create better discussions regarding the law. Thank you. Until next time.